Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about the anatomy of a divorce case from start to finish. Joining me once again is my co-host, Jesse Barrientos. Jesse, thanks for joining me.
Thank you, Dave. Nice
How
to
are
be
you
here.
this evening?
Very good. How about yourself?
Not too bad. This is a topic that you know quite a bit about.
I do a lot of divorce.
Not from a personal level, but from a professional level.
I'm glad you pointed that out.
Yeah,
exactly right.
We're going to try and walk the public through the anatomy, the start and finish of a typical divorce case. And we're going to try and keep it brief, try and keep it simple, because obviously these topics can get real in depth.
Sure they can.
But let's keep it simple. We've got a marriage that's having problems. Somebody comes to see you. They say what?
Well, a lot of times they say, hey, they're looking, they want to get a divorce. And what I like to do is I like to make sure first that, hey, there's no possibility of reconciliation because of the sanctity of marriage. You know what? If there's an opportunity for somebody to get back together and to reconcile, and especially if they have kids, even if they don't, you know what? Then that's something that's an opportunity they should take. And so once they're certain that that's it, it's over, they can't do it, we discuss some of the realities of divorce. It's kind of similar to just a regular civil action. The first thing that happens is you filed your complaint, your petition for dissolution of marriage.
Yeah, let's talk about the petition. It's got to contain certain elements. There have to be something called grounds. Can you walk us through what's involved in a petition to get us into the courthouse?
Sure. You have to allege that the parties, at least one of the parties, have been a resident of the state for more than 90 days preceding the filing of the petition. And if there's children, you have to indicate how many children were born as a result of the marriage. If there's any children that were adopted, if the wife is pregnant or not pregnant, that kind of thing. You have to allege that, to the best of your knowledge or the petitioner's knowledge, that there's been no other petitions filed, that there has been no determination with respect to custody in any other jurisdiction, foreign or Indian tribe or anything like that. That actually comes right out of the statute.
Then there's grounds.
Then there's grounds.
Let's talk about grounds, because we've got the facts all laid out, but there's got to be a reason for the court to grant you a divorce, and those are the grounds. You have to have them.
You have to have grounds. Illinois is a no-fault state, and so what that means is out of the grounds. And
no, it was his fault.
Talk about that. Yeah, that's what you usually say. His fault or her fault. But out of those grounds, the no fault is irreconcilable differences. It just means that you guys can't get along. And generally, there's a couple caveats with that. Generally, you have to live in separate and apart for a period of 2 years. That can be waived by stipulation by affidavit between the people. But then there's
reduced down to 6 months.
Down to 6 months. And the 6 months, you have to live separate and apart. But separate and apart, doesn't necessarily mean living separate and apart. A lot of times, people will still live in the same house. They'll just be like roommates. Sometimes they'll move to a different bedroom, and that's exactly what they are, roommates. They're really not living together like husband and wife anymore.
Okay, so as long as you're not functioning properly as a husband and wife, you can be living in the same house, under the same roof. But if you're living as roommates for at least 6 months and you both agree to reduce the irreconcilable differences waiting period from 2 years down to 6 months, you've got sufficient grounds at that point?
That's correct.
Okay.
And you can use that. Now, a lot of times, we do it in the alternative just in case the other side doesn't agree.
Talk about some of the other grounds that people might not know as much about that are a little bit more damaging than irreconcilable differences.
We have mental and physical cruelty.
Mental cruelty, explain that.
Mental cruelty, well, I guess it does depend on who you ask, doesn't it?
Yes.
It can be somebody, demeaning the other person, not appreciating their efforts, talking down to them, harassing them, being controlling over them. It can encompass a whole bunch of things. Another ground is adultery, and I think that certainly fits in the mental and physical cruelty, because if somebody else has been sleeping with somebody that's not you, then certainly that causes you mental stress.
Mental anguish, sure.
Exactly right.
Yeah. What about habitual drunkenness?
Habitual drunkenness, that we would think it would be not difficult to prove. There are other ways you go around that. I really haven't seen that so much. Generally the two kind of grounds, again, pled in the altar. Well, adultery, mental physical cruelty, and irreconcilable differences.
Yeah. One other that comes up a lot I want you to explain is desertion.
Desertion.
Which is different in Illinois than in other states. The word has a different meaning. In Illinois, all we're concerned about, what is desertion?
Desertion means that your spouse has just picked up and left for a year, and you don't know where their whereabouts are, and they just went out for a pack of cigarettes or a gallon of milk, and
so
that's
it's not that they
gone.
moved out, they went down the block with somebody else, and they deserted me.
No, a lot of people say
New York.
that. Well, I'm not sure about New York, Dave. I can tell you about Illinois, though. And yeah, for Illinois, you can't know where that where that person is.
Because I get phone calls. He deserted me. Really? Where is he? He's 2 doors
down the street with his girlfriend, right?
Okay, he didn't desert you. He moved out.
Right.
And that might be causing you some mental cruelty. There might be adultery, and it might be habitual drunkenness as well. But we've got grounds. Let's get past that point. We've got our grounds. We want to file our lawsuit. We want to move forward through the court system. What happens next?
Well, you file your petition, and again, there's a fee. Different counties charge different fee, and then there's a summons. You place the summons with the sheriff or with the special process server for the other person, the respondent, to be served. After they receive their the complaint, the petition for dissolution, they have 30 days to file their appearance, answer, or other responsive pleading.
Does it cost money to file the appearance? Does it cost money to file the answer?
It costs money to do everything, Dave.
Okay. Well, you got to pay for the judge, the clerk.
Well, yeah, it's got to pay for
bailiff.
the community services, exactly right, and that's what supports everything. And so, there's a charge when you file that, and then when you file your appearance, there's a charge for that too. There's a charge when you go down the sheriff, and very often they have a schedule of fees for travel time, and what they're going to charge you for where they have to go and to serve it.
Many clients are amazed at how expensive it is in terms of court cost to file a divorce case, and it wasn't that expensive to get married with the court.
Yeah, that's an interesting twist. They should make it just as difficult to get married as it is to get divorced, and maybe we wouldn't see as many dissolution cases.
Yeah, the filing fee right now is anywhere between $300 and $500, depending on which county you're filing in, which is quite expensive for people who don't have a lot of money,
right?
But need to get a divorce, need to move on with their lives.
Right, and you're talking, of course, include the appearance fee.
Yes.
As well to go along with that. Yeah.
Okay.
So
the appearance is filed.
Appearance is filed. Well, then the other party, they get served, right? And then they file their appearance, and then just like anything else, the discovery process begins.
Discover what?
Discovery. I need to know some facts, Dave. I need to know how much you're making. I need to know I want all of your financial documents.
But wait, the parties were together for 10 years.
Yep.
All of a sudden, you need to know. You didn't know. You were blind to the fact of what somebody made and what somebody had.
Well, that's part of your mental cruelty because you controlled everything, right?
Oh, I see. I didn't have access.
It could be. It's possible.
It is possible.
And a lot of times, in relationships, one spouse or the other is primarily responsible for all of the finances, and that's not a good thing. I want to, tell our folks at home, hey, you should know where you're at financially, especially in this economy. You should know how much you're making. You should know how much you're spending. You should know what your mortgage is. You should know how much equity you have in your house, which is something that could change from day to day these days, right?
But this discovery process that you're talking about is very time-consuming, cost-prohibitive. It takes a lot of work to actually gather the information, to respond to the requests. Isn't this a fee generation mechanism to a certain extent for attorneys?
Well, it does generate fees because it does take time. However, in order for me to do the best job I can for my client, and we're talking about here, a divorce is it's a court of equity. We're talking about equitable division of the property. So it depends upon a whole bunch of different factors that are outlined in statute. But if you've got a marriage of 10 years, and let's say you're making $150,000, and your wife is a stay-at-home mom, and she's been out of the job market, and in fact maybe she's put you through school so that you can be in this position. Now, there's going to be some other considerations with respect to equitable distribution. There's one thing you have to always think about is custody too, if that's an issue in the case or not. And we need to know a whole bunch of these things. So it does generate fees because it does take time, but it's essential unless the parties are in agreement. And unless they say, hey, this is what we want to do, you know what, we've talked, and this is the basic agreement, I'm going to keep half of his pension, he's going to give me child support, we agreed on a specific amount of maintenance for this little bit of time, or whatever the specifics dictate in that particular case.
So in this discovery, you're going to basically lay out all the parties' assets, liabilities, properties, income. You're going to look at the whole financial picture, because basically you want to be able to make a recommendation to your client, right?
That's correct. That's exactly
as to what is fair,
right,
based on the length of the marriage and the lifestyle of the parties and the different factors involved.
Right.
So discovery to you is a mechanism for you to be able to make a positive
informed recommendation to your client.
Right, unless, like I said, if the parties are in agreement and they're they're aware, they've both parties have had their hands in the finance and they know what's going on, and when you know that, then you can do limited discovery, or sometimes if there's agreement, not even discovery at all.
Full discovery, though, what is that going to set a client back in terms of time and money?
It depends on the time. It depends on how when you send one of the first things we do when we get the requests, and they're interrogatories, which are questions for people to answer. There are requests to produce, which are documents you want produced. There are financial declarations or comprehensive financials, income and expense affidavits, just depending upon which county you're in. They're titled something a little bit differently.
It may include a deposition.
Well, and it may eventually after you get everything done.
Under oath.
That's correct with a court reporter. After you have all of this discovery stuff. So what I normally do when I get those requests from the other attorney is within that day or that week get it out to the client and tell them that, hey, we need responses, because when you get it back from the client, it's not ready to go. You have to review it and to make sure that it makes sense, and you have to put it in a presentable fashion, and you have to go over it with the client before they sign off on it, just to make sure that they're that's accurate, that they haven't missed anything, and that everything is true and correct, because you're required to do that, because you're saying that this is what your situation is. Those are the answers to those questions. These are the documents that you have.
So this is not unlike a civil case where you basically want to gather all kinds of information so you can make an informed opinion on what your client's entitled to.
Right. No, it's very similar when it comes to those kinds of things.
Okay. So we've got the discovery done.
Right.
We've got everything laid out on the table. We know all the information about the parties. What we don't have an agreement.
Right.
The parties don't want to settle this case for whatever reason. Maybe somebody has a boyfriend. Maybe somebody else is holding out for a greater piece of the pie. Maybe somebody wants custody. Maybe somebody wants the house. What happens next? We're stuck, right?
Well, let me tell you. No, not exactly. Let me tell you, when you mention that too, somebody sleeping with somebody else, I hear that a lot. Oh, adultery, okay. And it's terrible, it's a bad thing, but that's just one of the grounds for dissolution. It's really not going to make that much of a difference. It may make a difference in a custody dispute or issue or something like that. It may, but with respect to anything else, it didn't make any difference at all. It's not.
So you can be a terrible spouse. You're still entitled to your fair share.
To your fair share,
and you're still going to be entitled to or forced to pay your fair share of the marital debt. Correct?
That's correct. Anything generally, as a general rule, any property or assets acquired during the course of the marriage are marital assets. Any liabilities acquired during that time are marital debts that are subject to equitable distribution. You have exceptions when it comes to, for example, a gift, inheritance, something like that. So let's say that
as long as it's kept separate.
As long as it's kept separate and you don't commingle it. So if you inherit, some money from a family member and it's kept separate and you don't do anything with it, then that's going to be your non-marital property. Now, let's say you inherit a house. And you still keep it separate, it's just in your name, but you have to fix it up, and you go and you fix it up and you spend some time over there. Then what the marital estate is going to want, what we're going to want, is contribution back to the marital estate for the assets and for the time that you've spent in building up this non-marital property. Sometimes referred to as dissipation.
Or sweat equity.
Sweat equity, yeah.
Okay.
Yeah.
Well, here's the deal, Jesse. The case is not going forward.
Right.
My attorney keeps appearing on continuance after continuance after continuance, it seems. I'm getting billed. The case is dragging on. I can't get on with my life. I produced everything that my attorney wanted me to produce. What happens?
Well, maybe you did, but maybe the other side didn't. Sometimes, continuances happen. All right, it depends upon what the case is up for. It might be up for status. There are various motions that happen too, and when I say by motion, might be in the interim before we get to a trial, before we take care of this thing. I want to get my client some support if that's what we're on that side. So I'm going to file a petition for temporary support, or maybe it's custody. So I'm going to file a petition for temporary custody or temporary and permanent custody. Okay, if custody is going to be an issue,
or continued contribution. Or continued contribution.
Exactly right.
Like
so,
the mortgage,
right.
And the utilities that all of a sudden somebody stopped paying because there was a disconnect.
Because they moved out. Right. And so those are the kind of things that happen. And then what happens when you file one of those things? The other side is entitled to respond. Generally, the courts will give them 21, 28 days, or depending upon the type of case or whatever. And then the other side sometimes wants time to reply to that response. Then you have a hearing.
Okay, so these are on a real kind of slow track, extended out with time to respond again, and then a hearing. We're looking at sometimes a couple months, right?
Well, yeah, it could easily be that in terms of getting that hearing. And then sometimes the docket, and again, depending upon where you're at, is so clogged that you might not get a hearing, depending upon which county you're in.
And that hearing is almost a mini trial, is it not?
It's exactly what it is. You have testimony, you present evidence, and then the judge makes a decision. I had one today. It was what they call a petition for rule. Basically, a court order was entered, and somebody didn't do what they were supposed to do. We filed a petition. They filed a response. It was continued. We had a settlement conference, and we'll talk about that in a moment. And then finally, it went to a hearing, and there you go. Then we have a disposition, and the case is set for trial sometime in January. But so people don't understand that these things do happen and they take time. Now, with respect to discovery, okay, so you might have done everything that you were required to do as my client, you sent everything in, but I might not have everything from the other side. Okay. You want everything from the other side, right? And so now you have the same motions I was talking about, different motions to compel, because you didn't produce these documents that I asked for, and we need those in order to make a determination on what's fair, what would be a fair distribution, because I want to look at those things. So, I mean, people really don't see. They might just see, well, it's continuing, I'm doing this and that. They don't see. Now, it could be that maybe it is just continuing and people are dragging their feet. That happens too.
Yeah, maybe one party doesn't want to let the other party go.
That's true too.
They want to keep them in the marriage as long as possible because they have a girlfriend.
That's true.
And they're ready to move on, but I haven't.
You haven't. Or maybe it's the attorneys.
I'm willing to pay you to keep it going.
Well, that's nice to hear, Dave.
Okay. But let's say we got all that behind us now.
Right.
And we've got everything laid out on the table. And it just comes down to negotiating a good settlement. How do we do it?
Well, I guess typically the petitioner will draft a proposed marriage settlement agreement or joint parent agreement or whatever. But I find that, whichever side I'm on, I try to settle it even early on if we can to identify the issues. Send it to the other side. Well, first, obviously, go through with your client. As long as it's acceptable to them, you send it to the other side. Okay. And then you get a response, and they say, okay, well, we like this, but these are the things we want to add or we want to change. Now you've identified, essentially, what the bones of contention are here.
Now, I've seen some of your settlement proposals, and they're very complex, several pages. It's not something that can simply be digested overnight.
No, that's true. And so that's why usually, and a lot of times with the internet, we just kind of email them over, and they, they get some time to look at it, to consider it, and then we go over those kind of things so that there's no misunderstanding about those things. And you make a good point here. Let me just mention that a lot of counties have simplified divorce packages. And that's a great thing with people who can't afford attorneys, people who don't have assets, and just go through these kind of things. And that's a really good thing. But, you really, 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 really need to be careful with those things. Because you have the judgment now, and that's it. I mean, if you don't have anything and that's it, great. If it's a little bit more complex than that, you really should seek out somebody who can advise you appropriately.
Right. Well, in a complex case, the person really shouldn't be representing themselves.
That's correct.
I know in Cook County, if someone's representing themselves, they'll be directed to the law library to look up a sample judgment. Well, that has to be tailored to the particular case, and they're going to miss things. Obviously, they're going to miss things. And it could cause a problem down the road, like you said, when something is not addressed. Maybe there's a piece of property that wasn't talked about, or a pension.
Exactly.
Or a debt. So, okay, so where do we go from here?
Well, so we get the kind of things that we're not in agreement on, and we try to work them out. Now, let's assume that the parties can't come to an agreement. Then we do, which was similar, I think, in a previous show we talked about, we have a settlement conference with the judge. And the judge, again, we also do a pretrial memorandum and identify those issues. And the judge is going to make a recommendation. The judge is going to hear things that he or she may not hear during the course of trial, evidence that may not be admissible, and he'll generally, or she'll generally admonish the litigants and let them know the same thing, that hey, that they might hear that stuff, and that understand that once they go back there and hear that, then you can't substitute them out if you don't like their recommendation.
Let's talk about this settlement conference, because I think it's very important. You're going to basically prepare a story prepared before the judge as to what you have involved here and what you want, what your client wants.
Right.
And you're going to meet with this judge. The two attorneys are going to meet with the judge outside the presence of the clients.
That's correct. That's exactly right.
Okay, so the clients are there that day, but they don't go back and hear what the judge had to say.
No, sometimes the judge will come out on the bench and address it, in a particular issue. But no, generally it's just the two attorneys, and they're gonna pitch their case. your attorney's going to say, well, hey, listen, she really doesn't deserve to have that much maintenance because it was only a 10-year marriage, and she's going to have the child support, and she should be paying some of this other debt off, and she's living in the house, and our position is going to be that, well, Judge, that's really nice, that might be right, but hey, what he didn't tell you is that she also took care of the kids, and she supported him and worked before they had the kids to send him to college so that he's in the place where he's at now. And she's taken all her time to raise those kids, and she's taken herself out of the job market. And so now she doesn't have any marketable skills. So she's going to need some way to compensate, some way to get those skills back in order to be able to be self-sufficient.
Will the judge spend sufficient time with the attorneys and with the pretrial memorandums? Or will the judge kind of do a quick blow-through and make a quick recommendation?
Well, my experience has been generally they'll spend the time. If they can settle it, they're interested in settling it.
What counties do you practice in?
We do DuPage, Cook, Kane. We also do Will, occasionally Lake.
And all those judges spend a fair amount of time with the pretrial conference for you?
Well, so far to my satisfaction, I haven't had one where a judge wasn't willing to give his or her effort and to go the distance to try to resolve
it. Could be the cufflinks.
It might be. It might be the cufflinks.
It could be the appearance, Jesse.
Yeah, that's possible.
Okay, because a lot of attorneys don't feel they're getting a fair shake in the pretrial, and they have to kind of convince their client that that's what the judge recommended, and that's likely what the judge is going to award if we go to a full bench trial.
Unless, and that's what a lot of judges will tell you, unless the evidence presented is drastically different. And, here's the thing that people should know, too, okay? It's about compromise. You're going to let this judge make a determination about your life.
Who doesn't know you.
Who doesn't know you.
Doesn't know your family.
Doesn't know your family. He's only, his or her only touch with this case and knowledge is going to be what's presented in the evidence in the course of a day trial, 2 days, a week, 5, just depending upon how complicated it is. Basically, it's a document trial. It's over assets, over liabilities, and in terms of custody, you have experts and evaluators and sometimes guardian items and stuff like that.
How persuasive your advocate was.
That's true. That's true too.
You might have a great case, but if your attorney can't sell it to the judge, it's never going to get the results that you're looking for.
Well, that's true if you can't get that evidence out. So, the thing is, you have control over your destiny. If you can settle it, okay, you know what? Settle it, because guess what? You've settled it. I think there's some statistics out there that kind of point to the fact that, hey, when people have had a hand in settling their own case, they're more likely to be a little more satisfied, and they're more likely to follow everything a little bit more closely than if it's crammed down the throat.
And in the long run, especially in a divorce case, isn't that the fact that most cases, the overwhelming percentage, do in fact settle without having to go to a full trial before the bench?
That's correct. They do. And again, it saves a ton of money. Because again, for preparation, there's and we can talk about that after we talk about the settlement segment. It's just in your best interest to be able to resolve those issues. But yeah, most cases end up settling.
Yeah. When I first started practicing, I was questioning how in the world does a divorce case go to trial? What is at issue here? It just comes down to division of property and allocation of debt. So really, it's not like the judge is making a guilty, not guilty. They're kind of doing equity, trying to make a recommendation based on the entire fact pattern. And is that one of the reasons why you don't see a lot of cases go to trial, in addition to the money?
Well, that is, and money definitely has a lot to do with going to trial or not. But I mean, it does come. The issues are over property, over whether or not you might think that that's non-marital property. Okay, well it was gifted, and okay, well maybe it was, maybe it wasn't. Maybe you're just saying that. So let's see some evidence. Let's look at it. Okay, maybe it's a significant amount of money, and maybe that's what we're fighting about. Maybe it was that property that you were going to buy in anticipation of the marriage, that you bought before the marriage, and so you're saying, hey, well, no, that's all mine. That's not marital. I had it before the So people fight about it's either property, debt, so assets, liabilities, or custody or visitation.
Do you find that a lot of your clients have unrealistic expectations at the outset? And then later, as the case progresses, and if you get to a pretrial recommendation, they start to understand that these are the parameters, this is what the court's looking at, and some of those early expectations may not have been accurate.
Right. Some of them have unrealistic expectations, and all you can do is advise them and just and tell them, kind of explain to them, and give them some of the scenarios. But some of them do. For example, I want child support, I want custody, but I don't want him to see the kid. I don't want him to have any visitation whatsoever. And just by some chance he should have visitation, I want it to be supervised. Well, guess what? Unless there's some just very very good reason, generally the non-custodial spouse, the person who doesn't have physical possession of the children, is going to get visitation. Children need both of their parents. And people, unfortunately, use kids sometimes in order to get back at the other person. Because what's going to hurt you most is not seeing your kid.
Right. Now, unfortunately, divorce is very prevalent. Even in cases where there's a quick settlement, a quick agreement, divorce is a heartbreaking situation. And it's always best, if you can, to try and rectify the situation before it leads into a full-blown divorce case.
Sure.
Because once it leads into that point, there's so much activity that happens in a negative fashion that it's often hard to reconcile that broken marriage at that point. But if you can catch it early, would you agree, you can prevent some of this heartache from manifesting itself?
I think you can. It's a death. It's the death of a relationship, and when you have kids, it shouldn't be. It should be a change in a relationship, because you're going to be in your child's life, and so is she. And you need to make it as easy as possible and seamless, for your kids.
Yeah, I think the courts do a very good job of admonishing the parties that even though the marriage is broken down, there's a child or children involved, you're going to have to work together. You don't want to make disparaging comments about each other in the presence of the children. You want to do what's best by the children, right. And that's the best interest of the child standard, and the parties should live up to that. They got to get over the anger.
Right.
They got to get over the fact that their relationship has broken down, but they got to do what's best for their child or children, because they're the ones who suffer the most if the parties don't do the right thing.
Right, and you do see the lot where they make disparaging comments about others. But you make an interesting point that, hey, most of the jurisdictions have a mandatory parenting class.
Talk about that parenting class.
Well, first it's a requirement. You have to do that before you can even, when you have kids, before you can even, get your divorce completed. And basically, they try to teach you, how to cope. They give you a lot of information, about divorce, about how to deal with the exact same issues that we're talking about. That's a requirement. A lot of times, too, what we have as well in the nature of settling things is required mediation. So if we're not agreeing on custody or we're not agreeing on visitation, then as mandatory, you guys have to go to an independent mediator.
And that's free. That's court-ordered mediation. That's free. It doesn't cost the parties anything?
No. It is. There's a cost for that, and you have to pay the mediator.
In Cook County?
And certainly in
mediation's free in Cook.
Well, in Will and DuPage, there's a list of mediators, and you have to pay their fee.
Every county's a little different.
Yeah,
but it's always best to settle your own case if you have one. Don't put it in the court's hands.
That's correct, because it's just going to be the judge. That's the difference here. You don't get a jury trial in a divorce case.
Okay. Thank you, Jesse.
You're welcome.
I think we've covered it. Divorce from start to finish. Jesse Barrientos and Dave Siegel. Thanks for watching Legal Action. We'll see you next time.